Well, I want to welcome you here tonight. As Julie mentioned, my name's Ron Adams, and I am an estate planning and business law lawyer located in Chandler. And what I want to talk with you about tonight has to do with the job of being a trustee, and more importantly, a successor trustee. You know, if you are named as a trustee under a parent's or a friend's living trust or an irrevocable trust, and we're going to talk today about, or tonight about, what that job entails, you know, what your duties are, what kinds of things you have to think about as a trustee. Now, while what we're going to talk about tonight also applies to any of you that are trustees of your living trust, of your existing living trust, you know, as the trustee of your existing living trust, obviously you have the power to control everything about that trust. So a lot of the things that we're going to talk about tonight don't really apply to you in your role as trustee of your own trust, but apply more to adult children or other people that you've named as the successor trustee to yourself within that living trust, or other types of trusts you might have. And we'll talk a little bit about what some of those other kinds of trusts are, and what the role of the trustee is in those cases as well. As a successor trustee, you know, and you move into that role and you start to collect the assets that are owned by the trust, well, what do you then do with those things? You know, what kinds of investments are appropriate for the different kinds of trusts that might be established within your living trust? So we'll talk in a lot of detail about, you know, what happens upon the death of the creator of a trust or the incapacity of the person that's created the trust. And, you know, as the next named trustee steps into that person's shoes, you know, what makes sense from an investment standpoint based on the purposes that the trust has been established for, and who's going to benefit by the trust that's in place. So let's first just start with some basics. You know, what is a trust? Well, this is a very complicated definition of what a trust is, as set out in the restatement of trusts. So this is the kind of language lawyers like to use to describe trusts. You know, it's a fiduciary relationship with respect to property, subjecting the person by whom the title to the property. Well, I'm lost already. You know, a trust is just an agreement that you create with yourself, and it talks to the issues of how are you going to deal with your property while you're alive, what happens and who's going to deal with it if you become incapacitated, and then ultimately, you know, how it's dealt with upon your death. And that's the basics of a trust. It's just an agreement with yourself. It has three basic parties to it. It has what we call a trust maker, the person that created the trust. Or in Arizona, because we're a community property state, you know, married couples often create joint trusts, you know, a single trust for the family. So they are both the trust makers. Were other words used to describe the creator of the trust? Settlor, trustor, a grantor, you know, all of these things mean the same thing. It's just the person that's created the trust. The second party of the trust is the trustee, the person that's in charge of holding the trust assets and using them for the benefit of the third party to the trust, the beneficiaries. But what is a trust? Well, there are different kinds of trusts. And like I said, trust is just this agreement you make with yourself with those various parties, the trust maker, the trustee, the beneficiary. But there are different kinds of trusts. A living trust is one that you might all be somewhat familiar with. That's the typical kind of revocable or amendable trust. Right? It's a trust you create, you move property into, but you can change it any time. You're not locked into anything by way of this living trust. It could be a testamentary trust. All a testamentary trust is a trust that's established under a will, the last will and testament. So necessarily, a testamentary trust is not one that gets created until the creator of the will dies. And within their last will and testament, they may establish a trust for certain people, children, other people, within that last will and testament that then describes how the trust works within the will. Now, of course, the disadvantage of creating a testamentary trust is you have a last will and testament in place that would have to go through probate at your death to establish the trust, and all of your assets would have to flow through that probate to get into the testamentary trust. So oftentimes, we may create testamentary trusts within last wills and testament, especially for younger couples that may have minor children who could not inherit assets outright. But more typically, in trust planning, we're going to create a living trust rather than a testamentary trust. There are revocable trusts, like the living trust, and irrevocable trusts. And now an irrevocable trust is what it sounds like. A trust that once it's created cannot be changed, cannot be amended. Typically used more so for tax purposes, estate tax purposes, or gift tax purposes. Now, we're not going to talk a lot tonight about irrevocable trusts, other than to say a lot of the rules we'll be talking about that trustees have to follow apply to irrevocable trusts, even more so than revocable trusts. But that's because, your revocable trusts become irrevocable at death. And the other reason we'll talk somewhat about irrevocable trusts is, those trusts that are created for beneficiaries at death that then become irrevocable, there's a lot of protections that can be built into those trusts that we'll talk about. And a lot of reasons why it makes a lot more sense to leave inheritances to children, adult children, in trust, rather than just giving them the inheritance outright.